history during the time frame, but every person they deny, they have to give a written notice. So if more than one person comes to rent the room in your home, you have to give a written notice now to every person that you don't rent the residence to or rent the room to. Is that not accurate?
Senator, has the floor.
Mr. President, my understanding is that the way it would play out is that there would be someone that they would be open to signing a contract with that individual, and that they then would check through the credit reporting agency. If the credit reporting agency indicated things such as non-payment of rent as a situation that the applicant had encountered, then they would have to basically give that individual the opportunity to assert that it was based solely upon non-payment of rent during the pandemic period, state of emergency.
Further question?
Mr. President, speaking to the bill.
Senator, has the floor.
Mr. President, I certainly understand what the gentleman says, and we don't have hard copies, so I do concede I'm reading this on my iPad, but the language clearly states if a landlord denies an applicant for tenancy, it doesn't say they have to deny it because of their rental history or because of any financial ability to pay, only that they deny them tenancy. Then they have to go through a list of other things. They have to give them written notice. They have to provide them legal aid notice and phone number. They have to wait a period of time before they can rent. So, Mr. President, conceding the fact that I'm looking at this only because we received it today, but that's a pretty onerous on an individual that's renting a room in their house, and that's the only rental obligation that they have. Certainly, if we're putting in place obligations for people that rent multiple units, that's why we've made different determinations for those, I understand. But to put this on individuals renting a single residence or a single room seems extremely onerous in this process, when clearly if they advertise, they're going to get more than one applicant and they're going to have to give notice to every single one. And if I take this to the extreme, they're going to, if they deny any, they're not going to be able to rent that residence or room until those time frames have passed before they can do that. So, Mr. President, I understand what the gentleman says. I am concerned that the words as presented don't do that and create a very onerous system for individuals who want to rent in Virginia, which I think will make renting harder and harder for people to establish places that they can rent.
Thank the senator. For what purpose is Senator from King George, Senator Stewart, rise?
Speak to the bill, Mr. President.
Senator, has the floor.
Thank you, Mr. President. I'd like to associate my comments with the gentleman from Fairfax and the gentleman from Hanover, and I guess just to give a little more perspective on this, where I come from, we have a lot of people who move into the area to teach school. And a lot of times they're from Pennsylvania or other areas, and they're trying to get their first job, and they're able to get a job in Virginia in rural schools. And so my mother taught all her life. That's what she did. And while I was away in college, she was at home by herself. She used to rent a room to a school teacher because she liked to have somebody in the house and because she liked school teachers. I think she charged them $150 a month or something like that, and they had full run of the house and everything. It was very inexpensive. She just liked the company and liked for the teacher to be there. And under this bill, someone who has absolutely no idea that they are obligated, I don't even know how you get this word out into Virginia to grandmothers and folks that want to rent a room out in their house, that if you don't comply with this, you're going to have $1,000 in statutory damages charged against you, and you got to pay attorney's fees. So if you want to have a teacher in your home and you charge them $250 a month, you could be subjected to several $1,000s in attorney's fees and statutory damages because you didn't file a stupid protocol. Mr. President, I don't think that's what anybody intended. And I'd hope that we don't vote for this bill.
Thank the senator. Senator from Fairfax City, Senator Peterson.
Thank you, Mr. President. Rise to speak to the bill.
Senator has the floor.
And, Mr. President, I hate to be part of the pile-on club, but this bill needs more work. One of the distinctions we've made during this special session is the distinction between small landlords who have 1 or 2 units and institutional landlords that have more than 4 units. Institutional landlords can handle a 22-line process about what you do with tenant applications. Small landlords, which include people like my in-laws, cannot handle that. Many of them don't even speak English. A lot of folks are, struggling using a couple thousand or, a few $100 a month that they get as income to live on. And to put this obligation on them, to me, is crushing. And I just think this needs to go back to the drawing board, so I hope we do not agree to this conference report.
Mr. President.
Senator from Eastern Fairfax, Senator Serville.
Thank you. This bill goes by temporarily.
I think I know where this is going. Any objection? No objection.
Thank you.
The bill will go by temporarily.
We have a communication from the House. The House of Delegates has acceded to the request of the Senate for a committee of conference on the following House bill. Conferees on the part of the Senate is named by the Chair of Finance and Appropriations, Senator Howell or Senators Howell, Barker, and Hanger. House Bill 5148.
Senator from Northwestern Fairfax, Senator Boysko.
Thank you, Mr. President. I move that we adopt the conference committee report. And
Senator has the floor.
speaking to the bill, ladies and gentlemen of the House, this is the earned sentence credit bill. And in the conference, we used the restrictions and the exclusions based on the House bill, which are more restrictive than what we passed here in the Senate. The other changes that we have made between the two bills, the Department of Corrections requested a number of technical changes so that it lined up with their regulatory method. We used the Senate's implementation language that I felt was very important. And because the Department of Corrections clarified with us that they already do recidivism studies, that language was stricken from the final report. The bill would go into effect on January 1st, 2022, which is halfway between the Senate's enactment date and the House's enactment date. And the work group that would be created by the implementation will be a staggered time frame starting next summer 2021. And I move that we accept the conference report.
Thank the senator. For what purpose is Senator from Eastern Fairfax? Senator Serville rise. Okay. Do any other senators wish to be heard regarding House Bill 5148? Seeing none, the question is, shall the Senate adopt the conference committee report? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 21, noes 18.
Ayes 21, noes 18. The Senate adopts the conference committee report.
We have been advised that there's no conference committee report on 5146. House Bill 5148. Oh, sorry. Senate Bill 5007.
Junior Senator from Richmond City, Senator Morrissey.
Good evening, Mr. President. Mr. President,
Good evening, Senator.
Speaking to the SB 5007, Mr. President.
Senator has the floor.
Mr. President, I move that we adopt the conference committee report. As the members remember, this is the bill that would allow defendants to have a jury trial but a judge sentencing. There are only 2 jurisdictions in the United States that have mandatory jury sentencing, the Commonwealth of Virginia and the Commonwealth of Kentucky. Despite pronouncements from some folk that it's going to be Armageddon and it's going to be an explosion of juries, it's neither. The conference report did the following. It stripped the reenactment clause from the bill, and it added a delayed enactment clause to July 1, 2021.
Will the
Mr. President?
senator yield?
Certainly, I yield.
Yeah, and I'm sorry.
You have the floor.
I would ask whether the senator would agree to allow this to go by for the day. I think this was one that we talked about, and I've talked to a constituent group who has some concerns and would like a day to look at this. So with that, I would ask it to go by for the day.
Senator's the floor.
Mr. President, I'm going to defer to the senator from Fairfax County. I didn't have any discussions. Perhaps he had some agreement with the senator from Rockingham County regarding passing it by for the day.
Do any senators wish to be heard regarding the motion? Is the senator ready for a vote on that motion? Or did you still want the floor?
Mr. President, not seeing any objections from anyone, then I'll agree to pass it by for the day.
Without objection, Senate Bill 5007 will go by for the day.
Senate Bill 5018.
Senator from Loudoun County, Senator Bell.
Thank you, Mr. President. Mr. President, I move the conference report and speaking to the motion.
Senator has the floor.
What we did on this report is this is the compassionate release bill. The current law would actually allow release at the 3-month time frame. This would not be actual release, but actually allow terminally ill prisoners to apply for consideration for release. What we did is leave the current law alone, moved it to 12 months where they could apply for consideration. Doesn't mean they would be granted. And we excluded murderers, which we had done previously in the discussions here. We also excluded all violent crimes and a number of other crimes if there was a subsequent repeat offense. With that, I move passage. Adoption of the, excuse me, Mr. President, adoption of the committee report.
Thank the senator. For what purpose, Senator from Hanover, Senator McDougall rise?
Mr. President, would the gentleman yield briefly for a question?
Will Senator yield?
Mr. President, I yield.
Senator yield, you have the floor.
Mr. President, again, I apologize, but having gotten these a little late on our systems, I just want to ask the gentleman, is there any description or is it left up to the parole board to determine the medical prognosis? Does it have to be by a doctor or is that process to be determined by the parole board later?
Senator has the floor.
The way I'll read from the code and then I'll expand on that, Mr. President. The way that the bill says it's terminally ill, meaning a chronic progressive medical condition caused by injury, disease, or illness, where the medical prognosis is the person's death within 12 months. The current Department of Corrections regulations on this require 2 medical doctors certify that. And oftentimes what would happen is if it's a, for instance, cancer diagnosis, it could be a specialist at VCU who is separate from the doctor at the Department of Corrections, and then the Department of Corrections doctor would also certify that diagnosis after reviewing the records. And then the parole board follows those diagnoses and recommendations.
Further question?
Mr. President, would the gentleman yield for additional questions?
Senator yield?
I yield.
Senator yield, you have the floor.
Mr. President, I understand the gentleman's articulation of the current policy of the Department of Corrections, but this is a parole board determination, not a Department of Corrections determination. So my question is, will the parole board, do they have the authority to make up the determination of what evidence or supporting documents they would accept to determine a medical prognosis?
Senator has the floor.
Mr. President, in accordance with the code, the way this is written in the conference report, they would have to have the terminal diagnosis from medical doctors, the parole board, in order to consider, again, just to consider release, not to grant.
Further question?
Thank the gentleman.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 5018? Seeing none, the question is, shall the Senate adopt the conference committee report? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? Clerk, close the roll.
Ayes 22, noes 16.
Ayes 22, no 16. The Senate adopts the conference committee report.
Senate Bill 5030.
Senator from Hampton, Senator Locke.
Thank you, Mr. President. I move that the conference committee report be adopted by the Senate.
Thank the Senator. You have the floor.
Thank you, Mr. President. And the senator from Eastern Fairfax and I will be tag teaming on the changes that have been made to this report. Speaking to some of those changes, we tightened up the language on training for law enforcement officers with regard to mental health awareness, racism, and implicit biases. We also require training on the handling and use of tear gas and kinetic weapons with regard to officer hiring. The conference report goes with the Senate language, encouraging psychological evaluations for new hires, which meant that we did not go with the House's approach to mandating that the psychological evaluations. And current and former law enforcement officer employers also need to provide any information relating to the termination, dismissal, demotion, suspension of any law enforcement officer, not just information about civil suits, internal investigations, or an arrest. The bill also requires all law enforcement officer applicants to sign a waiver for prior employee records, not just hires from out-of-state employers. The bill further requires all prior law enforcement employers to turn over records within a 14-day period. With regard to the advisory boards, we stuck with the language with respect to social justice organizations. With respect to decertification, somehow the language with respect to requiring a working group to come up with a new officer code of conduct had been stricken from the legislation in the House. That language has been reinstated into the legislation. We accepted some language that had been in the House bill that added carnal knowledge prohibition for people who are seized but not actually arrested yet. We also added a definition with respect to excessive force from failure to intervene. That bill has already passed. The House bill, that is, has already passed. And we also rejected all the language that was in a previous House substitute with regard to tear gas and other restrictions on the use of kinetic weapons. I will now, Mr. President, if you don't mind, yield to the senator from Eastern Fairfax for some additional explanations.
Thank the Senator. Senator from Eastern Fairfax, Senator Servell.
Thank you, Mr. President. First of all, if anybody would like to see a red line of this bill compared with the bill that passed the Senate, I've got it here on my desk if you want to see it. But I'm going to just try and go through this really quick, looking at the PDF lines. First of all, on the equipment piece, which I know is of interest of some of the members from more rural areas, we added a few of the items that the House requested, including weaponized drones, weaponized helicopters, the acquisition of grenades, and something called MRAPs, which are these big multi-axle things they used in Iraq and Afghanistan that have V-holes that deflect IED blasts. We didn't think law enforcement needed those. But the request of the sheriffs on lines 33 through 38, I know we have a specific language that makes it clear that the sheriffs can buy armored Humvees, which I know is a request by some people due to rescuing people in certain terrain or in floods. We also have in lines 39 through 50, or actually through 55, a waiver process. So if anybody already has some of this equipment, they can get a waiver from DCJS and they can continue to use it. We also made clear we're not doing anything to the National Guard. Then the Senator from Hampton, I think, Mr. President, noticed went over some of the training things that have changed, but we're making it clear that DCJIS is going to promulgate clearer uniform training for both current officers new officers, more awareness of racism, implicit bias, working with people with mental illness, substance abuse disorders, or cognitive disabilities. The House language has, I think, more robust language about that. We've added training about the handling of kinetic weapons and tear gas, but just training on that. All the House's measures that had to do with restrictions on tear gas are not in this bill at all, and much of the restrictions they had on kinetic weapons are not in here. I'll get back to that in a second. Then, Mr. President, if you get over to lines, let's see, lines 530 and 531, the Senator from Hampton mentioned we are not mandating psychological examinations like Senator Carrico would have wanted us to, because there's about 4,000 of those that have to happen a year, and we only have 5 certified psychologists in the state that can actually do the psychological exams. And the chiefs of police talked to me about how they want to actually try to encourage that and make that standard practice. We just don't have the human infrastructure in place to do it yet, and so that's why we went with the discretionary approach, even though we'd like to have a mandate. Then if you go over to line 13, I know the senator from Rockingham had some questions about social justice organizations. We stuck with the Senate language on that. That's still in the conference report. Then one of the big things that was in the Senate bill that is not in this bill were 2 provisions having to do with HB 599 funds. If the body remembers, many of the law enforcement leadership in the state wanted us to try to do something to encourage accreditation, because out of the 400 and some law enforcement agencies in Virginia, only about 60 plus or minus are actually accredited. And so we put in language that said you lose your increases in 599 funding if you do not get accredited within 4 years. The House didn't like that and struck it. We also had language that said you lose your HB 599 funding if you do not comply with the Community Policing Act. They didn't like that either, and they struck it. So many law enforcement agencies are actually not compliant with that, but there's really no consequence for it right now. But that language did not get included in this bill. Then, let's see. Also, on the officer hiring, if you look to page 31, lines 787 through 798, if you remember, the former bill required new employees to provide a waiver if they're coming from an out-of-state police agency. This requires every new police officer to provide a waiver. In addition, it also requires the former employer to provide any information that related to a sheriff or a former police officer's dismissal, resignation, demotion, suspension, or transfer. So they formally only had to provide the information if they were fired, or if a criminal charge was brought against them, or if there was an internal investigation. But the House had broader language, which we liked, and we included that. Also, at the suggestion of the senator from Spotsylvania, we added language that says that when a law enforcement agency makes a record request to another sheriff, they have to turn over their old file within 14 days. There was some concern that some sheriffs might slow walk record requests because they're unhappy their guys are getting hired away from them, or maybe they don't like the place that the sheriff might go or the police officer might go. So anyway, we have that 14-day trigger in there. We appreciate that suggestion. Everybody thought that was a good one. Lines 948 through 74, that has the House language about carnal knowledge. We've already passed the House version of that bill, but that's different in this bill. Then if you go over to lines, starting around line 1086, this is as the search warrant language, which a lot of people had questions about, and this is a little bit different than what we saw before. First of all, it is a no-knock ban. The Senate did pass a no-knock ban when the House bill came through, and that's what this approach is. It's a no-knock ban. It still also has the ability to serve a warrant at night if you get the permission of a circuit court judge or a magistrate if you can't find a circuit court judge. However, we added some language from the House bill that when you go into a house, you have to be recognizable, identifiable as a uniformed law enforcement officer. And there's also language that when you knock and announce yourself, you have to speak in a manner that is reasonably expected to be heard by the occupants of the place to be served. I can't remember what the prior language was, but it was a little tight, it was a little, I would say more ambiguous. Anyways, reasonably expected to be heard, we thought was a better standard. The senator from Roanoke came up with that one. And then we added some language on between line 1093 and 99, which just says that after you enter the place, you have to read the warrant to the person who's inside, and you have to, or leave a copy of it if nobody's home when they go in. Then if you go to lines, starting on the next page, lines 129, this has to do with the use of force section. First of all, we had a definition for excessive force between lines 1137 and 39. That came from the House duty to intervene bill, which we've already passed. We've already passed the House version of that. That's where the excessive force definition comes from, and that appears, excessive force appears throughout this. So we've already passed that. However, the changes that you all have not seen yet is, first of all, on lines 1155 and 1159, 58 and 59, that's the chokehold and the shooting at a moving motor vehicle language. We put a little tighter language in there to make it clear that that the exception for chokeholds and the exception for shooting at a moving motor vehicle only apply if you're trying to protect a law enforcement officer or a third party from death or serious bodily injury. There was some concern that the exception was a little ambiguous and it left it even more wide open than that for a chokehold. But we've tightened that up, and that's language that was suggested to us by DLS to make it clear that we're only talking about self-defense of yourself or others. And as I said last week, which apparently the media didn't absorb, and I'm going to say it one more time to be clear, this bill is a Class 6 felony for law enforcement officers who commit chokeholds that are not accepted, okay? Because it takes away the unlawful force defense under the strangulation statute. And if you don't understand what I'm saying, please call me. And don't report it wrong. Another thing I'll say is in lines 1160 to 62, there's language limiting the use of kinetic munitions, which are beanbags and rubber bullets, but you can use them to prevent another person from bodily injury. That's a very broad standard, but there's concern in the House. Apparently one member of the House had a nephew who suffered a brain injury, traumatic brain injury from an impact from a rubber bullet, and they felt very strongly there had to be some limitation. But this says that you can use those kinetic weapons if you're trying to prevent bodily injury. Then, aside from that, one other change on lines 1247 to 48. This is the provision about records that Commonwealth attorneys can access. The law enforcement didn't understand why Commonwealth attorneys should be able to access a law enforcement officer's file in a forfeiture proceeding. Given that we've now made forfeitures only possible after you've been convicted, that made sense to us, so we removed forfeiture proceedings from their ability to access records at that point. And then, what else? We also had a working group to develop the officer code of conduct. The House didn't like that. They acceded to our position on that and left it in here. But Mr. President, those are the changes to the bill. I want to thank the senator from Hampton for allowing me to work on this with her. And I also want to thank DLS, who worked their butt off drafting this bill over the last 3 months. And I think with this legislation, we're going to have a stronger law enforcement community in Virginia that has a greater trust in the community. And I think we're going to have a much better, or much more enhanced ability to weed out the bad apples in the force so that they don't continue to serve in other jurisdictions after they have issues where they've been serving. And with that, Mr. President, I would hope we adopt the bill, and I can't remember if the senator from Hampton moved to adopt it, the conference report, but I would renew her motion.
Mr. President.
Thank you, Senator. For what purpose is Senator from Rockingham, Senator Obenchain, rise?
Mr. President, I would ask if the senator from Eastern Fairfax would yield for a couple of questions.
Senator Yield?
I'll yield.
For a couple questions. Senator Yield, you have the floor.
Mr. President, first of all, I want to thank the senator from Eastern Fairfax for providing copies of this bill to a number of us this morning. The conference report, I actually did go through it before I got on the road and traveled to Richmond. I do have a couple of questions. First, I would direct Senator's attention to page 2 of the conference report, line, I guess, 26. Grenades, I know that was in the original version, but does that include things like flashbangs and tear gas?
Senator, the floor.
Mr. President, I would say that grenades do not count as those things. Grenades, I would think, are things that are designed to hurt people, but I would point out that grenade launchers, the way law enforcement described it to me, is that you actually use a grenade launcher to launch a tear gas canister. And so we tried to make it clear we're not banning grenade launchers generally. We're only prohibiting law enforcement from acquiring grenade launchers via the federal surplus program. That's why on the grenades or grenade launchers program, it has the extra language about from a surplus program operated by the federal government.
So, Mr. President, further questions. So,
Senator Yields, you have the floor.
So if I understand, with respect to grenades, the senator is informing me that he is confident that the word grenades does not include flashbangs and tear gas.
Senator, the floor.
Mr. President, what I would say to the senator is that was not the intent, and it doesn't use those words. I mean, I can't predict what a judge would do, but our intent was not to ban the acquisition of tear gas or flashbangs from the United States military.
All right.
The
Further
question? Senator Yields?
I'll yield.
Senator Yields, you have the floor.
And with respect to grenade launchers, the intent is to require local agencies to have to buy them but not get them for free from the federal government.
Senator, the floor.
Mr. President, that's correct.
Okay. Mr. President, I would ask Senator from Eastern Fairfax if he would turn to page 33, excuse me.
I'll yield.
33 of the report. And I don't know whether this language has changed, and if it has not, I apologize for not picking this up before, but let me give you a scenario. An officer is confronted with a serious incident of misconduct. No investigation has started, and that officer may have used excessive force, unquestionably used excessive force. But upon returning to the police station, he says, I resign effective immediately because I want to spend more time with my family. Is that not something that would evade the purpose of this bill because he did not resign for engaging in serious misconduct? He or she resigned for an alternate purpose?
Senator has the floor.
And I'm looking at line 842.
Right. Mr. President, first of all, there's nothing in this language that changed between the Senate bill that passed and the conference report. I would just first of all note that. What I would say to the senator is I think it would be up to the sheriff, the chief of police, or the agency administrator to make a judgment about whether that officer resigned for engaging in serious misconduct as defined in the statewide professional standards, which are going to be developed and promulgated subsequent to the adoption of this. And so I think it would be up to that chief to make that judgment.
So the police...
Further question?
Further question.
Senator Yield?
I'll yield.
Senator Yield, you have the floor.
And as I understand this, Senator, you're saying that no matter what the officer says is his or her reason, that the judgment of the police chief or sheriff trumps that, even though the express language of the statute says that the officer resigns for engaging in serious misconduct. It's the judgment of the chief law enforcement officer, not what the law enforcement officer who resigns says. I guess my question is, does this create an opportunity for mischief by officers who engage in serious misconduct, but who are smart enough or have savvy enough counsel to avoid showing up in the database by following that advice?
Senator has the floor.
Mr. President, what I would say is that if you look at the 6 Romanettes here, some of them have lines which I think are a little brighter than others. So, for example, Romanette number 5 makes it clear that if you resign while you're subject to a pending internal investigation, I think there's probably clarity as to whether or not a pending internal investigation is going on or not at the moment of resignation. And so, for example, on that one, there's a clear line. With regard to that one, with regard to the example that the senator is giving, it's the sheriff, the chief of police, or the agency administrator who has to make the decision whether to notify the board. And so they're the one that makes that judgment, and they're the ones that are going to have to decide what the reason for the resignation was. And this statute doesn't really say anything about whether they have to take the officer's word for it or not. And so I would submit it's on them, and if there's a failure to report, it would be on the sheriff, the chief of police, or the agency administrator. The responsibility or the liability or the consequence would be on them, not on the officer. So I would think they'd probably talk to their attorney and say, you know, hey, this is what happened, what should I do? They'd have to make that judgment.
I thank the gentleman. Further question?
Senator Yield.
I'll yield.
Senator Yield, you have the floor.
I would ask Senator from Eastern Fairfax to look at page 43 of the conference report, and I believe this is one area where he indicated that the conferees did make some changes, and some of those changes I like, some I'm concerned about. One that raises some concern is the language that seems to have been inserted on line 1095 that says that after entering and securing the place to be searched, and prior to undertaking the search, the executing law enforcement officers shall read and give a copy of the search warrant to the person to be searched or the owner of the place. So I'm concerned because, and ask the gentleman, this is followed by an exclusionary provision. So if the officer doesn't read the search warrant to the occupant or owner of the premises, whatever evidence is gotten is thrown out. It's inadmissible. So what happens in a case in which the resident or owner is injured and has to be evacuated? In that instance, it may not be practical to read it to the owner or occupant. And I wouldn't question the judgment of the police officers, but I mean, are they really required to keep him there over the advice of rescue personnel in order to read the warrant to them or face the exclusion of all of the evidence that is obtained during the course of that search?
Senator has the floor.
Mr. President, first of all, I agree with your suggestion that if the statute, if a judge were to find that the statute is not complied with, it results in exclusion. I think that's what the language bears out. But I would also note that at the bottom, on lines 1097 through 99, it says that if the place to be searched is unoccupied, they can simply leave a copy there and affix it to the place to be searched. And I think the question for the person at the scene, and then later probably for a judge if the issue was raised, is whether or not the premises were unoccupied if the occupant was removed because they had a medical issue. And it would seem to me that a reasonable judge would find that if somebody had to be removed because they just needed medical attention, that the unoccupied provision would kick in at that point, and that part, the part about reading it to them while they're writhing in pain or bleeding or whatever and needing medical attention probably would be excused. That would be my interpretation. If I were a judge, that's how I'd apply it, given the scenario you gave. But obviously, I can't, I don't have a crystal ball.
Further question?
Further question.
Senator Yield. Senator Yield, you have the floor.
And I would assume further that Senator from Eastern Fairfax would apply that same logic, or I guess wishful thinking, to hope that a judge would apply that same logic to a case in which the person who owns or occupies the premises is violent, uncontrollable, has to be arrested and removed from the premises, that the court would not conclude under those circumstances that they had to read the warrant to that person before removing him or her from the premises.
Senator, has the floor.
Well, Mr. President, first of all, you know, those types of adjectives are always obviously in the eye of the beholder, and I would hope, given the requirements that we're placing on our law enforcement in this statute, that anybody going into a premises on a search warrant would hopefully wear a body camera so that we'd have clarity about exactly what happened and just how violent or uncontrollable or whatever that person might be, so that there's clear evidence of that and we're not having to trust somebody's characterization of it. But having said that, I would submit that if the occupant was making it impossible to comply with the provision, that I don't think the reasonable judges that we tend to select, or at least that I tend to look for to put on the bench, would want to excuse that requirement due to the conduct of the occupant. I can't speak to the judgment of the men and women that you put on the bench in Rockingham, but I would hope that you'd pick suitably well-qualified judges which would feel the same way.
Further question.
Senator Yield.
I'll yield.
Senator Yield, you have the floor.
And I noticed elsewhere in this bill there was language inserted about exigent circumstances. For example, in cases involving the use of deadly force. My question would be, did the conferees consider even remotely the possibility of putting an exigent circumstances language in the provision dealing with staying and reading a search warrant at risk of exclusion of all of the evidence that is the product of that search warrant?
Senator, has the floor.
Mr. President, I would say to the gentleman that I think we did consider we didn't consider exigent circumstances language because we assumed that exigent circumstances always apply, so that if there is ever an exigent circumstance, the Fourth Amendment goes out the window. So that, you know, it's not necessary to put the language in the statute, I think, was the drafting approach that we took.
Further question.
Mr. President, would the gentleman from Northern Fairfax, Eastern
Sure.
Fairfax, yield?
I'll yield to the junior senator from Richmond, who probably has more search warrant experience than I do.
Senator, has the floor.
Thank you, Mr. President. I would tell the gentleman from Rockingham that I don't think it's necessary that you put in the particular bill the notion of exigent circumstances. I would tell the gentleman that there are always exceptions to the search warrant requirement, whether it's the fleeing felon exception, the automobile exception, the exigent circumstances exception, or the Leon good faith exception to the search warrant requirement. A judge will consider those things without it being spelled out in the legislation. I hope that would assuage the gentleman's concern and maybe prompt him to support the bill.
Mr. President,
Senator's floor.
I would ask either of the learned gentlemen this follow-up question. Isn't it true that exigent circumstances presumption deals with the minimum constitutional prohibitions, but that the General Assembly is permitted to enact legislation that's more restrictive than the minimal limits imposed by the Constitution? And that is precisely what the senator from Eastern Fairfax in his work on this is intending to do, is not to simply rely on the minimal standards imposed by the Constitution, but to tighten it up and to impose more restrictions on law enforcement than the Supreme Court imposes on law enforcement under the jurisprudence established under the Constitution.
Well, if I understand the
Junior Senator from Richmond City.
Thank you, Mr. President. If I understand the senator's question, I would say this. The standards are set by the Constitution. It's got to be reasonable. You can't, it has to, and in this particular case, exigent circumstances, that only applies to the execution of the search warrant, not the application for the search warrant. And in the execution of the search warrant, of the search, the court, and when considering whether to suppress the evidence, will consider the notion of exigent circumstances.
Further question.
Senator Yield.
So
Senator Yield, you have the floor.
What I am gathering is that the conferees or senator from Richmond or the senator from Eastern Fairfax believe that it is unnecessary to put exigent circumstances language in here. And if indeed that is the fact, why is exigent circumstance language in here with respect to the use of deadly force? Is it unnecessary and surplusage with respect to that as well?
Senator has the floor.
I would tell the senator that, as I said earlier, you do not have to spell out in legislation or in the Virginia Code the notion of exigent circumstances. The court deciding whether or not the warrant was proper, the search warrant was executed properly, and whether or not to suppress the evidence that was seized will consider the notion raised by the defense attorney, were there exigent, or the Commonwealth, were there exigent circumstances. I think the senator's question is, why was it raised in one area and not the other area? I'm going to be, I don't want to plow that territory. I don't know. I'm sorry.
I guess my follow-up question would be, what's the harm? What would have been the harm in adding it?
Mr. President.
Senator has the floor.
I'll yield. Thank you, Mr. President. First of all, Mr. President, I just did a quick search of Senate Bill 5030. I don't see the words exigent circumstances anywhere in the bill. If you see it on the line, I'd appreciate if you could point me to it, but I'm not aware of exactly what the default drafting rules are with regard to about whether or not, you know, by not mentioning exigent circumstances, you're overwriting it. My assumption is that the exigent circumstance search warrant exception exists and always trumps everything until we specifically say it does not. And I would also assume that our DLS counsel and our Senate committee staff counsel would be would catch that type of issue for us during the committee process. And I'm sure, obviously, as this bill goes through, the Attorney General's office and the Governor's office can look at it too. And if that assumption is incorrect, I'm sure it'll get pointed out to us, because that's not what the intent is.
Further question?
Further question.
Senator Yield.
I'll yield.
Senator Yield, you have the floor.
I would ask the senator to direct his attention to page 47, the section dealing with excessive force, particularly here the section dealing with the failure of a law enforcement officer to intervene in the use of excessive force. On the previous page, this is where exigent circumstances are spelled out. Law enforcement officers are allowed to use deadly force in circumstances in which they have reason to fear for their personal safety or life, or the life and safety of another. Those are the exigent circumstances spelled out there. And in the portion dealing with the use of deadly force, it says that that deadly force shall not be used unless that particular law enforcement officer perceives or reasonably believes that there is that justification. My question is, this section dealing with the failure of others to intervene, how does one law enforcement officer form the judgment? How does he know what another law enforcement officer has seen or perceived? Are you putting a law enforcement officer in a position of having to presume that his or her partner is illegally using excessive force if they don't see the gun or the knife or the threat that their partner is seeing? And are you putting law enforcement officers' lives at stake by saying, if you didn't see the same thing as your partner, you've got to jump in and pull your partner off of that person, even if it turns out that they had a gun, because you didn't see it.
Senator, has the floor.
Mr. President, what I'd say is a couple things. First of all, with regard to your question a minute ago, I received a bulletin from DLS that says this statute only applies when people are executing searches pursuant to search warrants, and if there's exigent circumstances, that's a search that's not pursuant to a search warrant. And so this wouldn't affect that. That was at least the interpretation of, I think, the counsel we got from in committee. Secondly, with regard to the question you just asked, I think you are characterizing certain circumstances as exigent circumstances, even though the statute doesn't call them that. The statute doesn't use those words. And as I said in committee hearing, this language was based on the case of Graham v. Connor, which is a U.S. Supreme Court case from 1989, the factors that are set forth in lines 1182 through 1191. And I have that case somewhere in this pile here, which I haven't gone back to read to see if the Supreme Court calls them exigent circumstances or not, but in any event, we seem very focused on that term. But with regard to your question otherwise, the excessive force language comes from the case of Cromartie versus Billings, which was a Supreme Court of Virginia case that was decided, I believe, just this year. And that was where the definition of excessive force comes from. So I would submit that with regard to that, it creates a duty to intervene when the police officer believes there's force being used that's objectively unreasonable given the totality of the circumstances, including the severity of the crime, whether the subject posed an immediate threat to officers, and whether the suspect is actively resisting arrest or attempting to evade flight. And I think that's the standard by which the duty to intervene would be judged. It's the language on lines 1137 through 1141.
Senator, has the floor.
Mr. President, further question.
Senator Yield.
So,
I yield.
Senator Yield, you have the floor.
if an officer sees his partner draw his firearm and prepare to shoot a suspect, but doesn't see the suspect has a gun, doesn't see a gun, he has a duty, it would seem, under this statute to stop his partner or her partner from firing, even if that person, the suspect, actually does have a gun.
Senator, has the floor.
True? Ain't that true?
Well, Mr. President, I would say that the only person that I've ever seen that's capable of knowing a gun is being shot before it's fired is Neo in The Matrix. And so I'm not sure how a police officer is supposed to intervene in somebody pulling a trigger. I would think most people don't have the kinds of reflexes that would prevent the trigger from being pulled. And so in that particular circumstance, I would think that it's kind of impossible for an officer to stop another officer from pulling the trigger when that starts. Obviously, if you're talking about somebody using a club, or for example the George Floyd situation, which is largely what brings us here, where you have somebody sitting on somebody's neck for 8 minutes, that's obviously pretty obvious, right? So, I think the idea, though, that an officer could stop somebody from pulling the trigger is not really plausible because human reaction time just isn't that quick.
All right. Mr. President, I thank the gentleman. If I can speak to the bill.
Senator, has the floor.
I thank the senator from Eastern Fairfax, and I think that this bill, as is evidenced by some of these issues, raises some serious questions. I think that it's going to continue to put more law enforcement officers' lives at stake. It's going to result in law enforcement officers being hurt or killed at an increasing rate. It is, I would respectfully submit, going to make it unnecessarily difficult to get convictions in crimes in cases where this bill could have been tightened up to make it clear that, that there are exigent circumstances that would justify, for example, not reading a search warrant to the owner of a home. I think that opportunities were missed here. We are casting a suspicious eye on law enforcement officers. We can always point to the George Floyd situation and situations like it in which every single one of us would agree that a crime was committed not just by the officer with his knee on the neck of the suspect, but by his or her partners who stand by knowing that a crime is being committed. But my concern here is that this is putting the lives of law enforcement officers unnecessarily at risk.
What purpose is Senator from Hampton, Senator Locke, rise?
Thank you, Mr. President. If no one else wishes to speak on 5030.
Do any other senators wish to be heard regarding Senate Bill 5030? Seeing none, Senator has the floor.
Thank you, Mr. President. I once again move that Senate Bill 5030 pass, that the conference report be adopted. And Mr. President, this is not about putting the lives of law enforcement officers in jeopardy. And it is not only about what happened to George Floyd, because the Commonwealth of Virginia is not immune to what happened to individuals like George Floyd. Incidents of excessive force, incidents of misconduct have happened in the Commonwealth of Virginia. Had it not, we would not be standing here today with this piece of legislation. And what we will hope that would happen as a result of this legislation is that we root out individuals who do not need to be law enforcement officers. And we have gotten the buy-in of law enforcement. We've talked to state police, we've talked to sheriffs, we've talked to chiefs of police with regard to what it is that we should put into this legislation. We did not do this in a vacuum. You know, we sought the input from stakeholders with regard to this legislation. You know, we were not trying to do this under the cloak of darkness. So thank you, Mr. President, and again, I move adoption of the conference report.
Thank the senator. Question is, shall the Senate adopt the conference committee report? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? Clerk will close the roll.
Ayes 21, noes 17.
Ayes 21, noes 17. The Senate adopts the conference committee report.
Senate Bill 5034.
Senator from Northwestern Fairfax, Senator Boysko.
Thank you, Mr. President. I move we adopt the conference report, and speaking to the motion.
Senator has the floor.
Thank you, Mr. President and members of the Senate. SB 5034 contains two bills that we have already voted on today. One was Senator Bell's Bill 5018, which deals with conditional release of geriatric or terminally ill patients, prisoners. The other was HB 5148, which is the Earned Sentence Credit Bill. Having explained them before, I move that we pass the bill and want to just remind the body that Virginia is ahead of the rest of the country, more than half above the average of incarcerated individuals in the United States. The United States is the highest level of incarceration in the entire world. This is important work. This is a first step. I want to thank all of the stakeholders who have participated with this. I've gotten to know families who have incarcerated individuals. This is a life-changing bill and has the opportunity to move our system forward, and I hope that I have the support of this body. Thank you.
Thank the senator. For what purpose is the senior senator from Chesapeake, Senator Cosgrove, rise?
To speak to the bill.
Senator has the floor.
Thank you, Mr. President. If you look in the conference report, you'll see that I signed this bill. That was more of a complimentary gesture towards the senators from both northwestern Fairfax County and eastern Fairfax County. Unlike some of the other conference reports, they both talked to me about the conference report. They were very informative, and I thank them for including me in their conversations. I won't be supporting the bill, but I do have to compliment them on working together, at least with this senator. Thank you.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 5034? Seeing none, the question is, shall the Senate adopt the conference committee report? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? Clerk will close the roll.
Ayes 21, no 17.
Ayes 21, no 17. The Senate adopts the conference committee report.
Senate Bill 5035.
Junior Senator from Chesterfield, Senator Hashmi.
Thank you, Mr. President. Mr. President, SB 5030. Mr. President, I move that we adopt the conference committee report for SB 5035.
Thank the Senator. You have the floor.
Mr. President, SB 5035 is identical to the House Bill 5055, which this body just passed earlier today, and I move that we pass this identical bill. Thank you, Mr. President.
Thank the Senator. Do any other senators wish to be heard regarding Senate Bill 5035? Seeing none, the question is, shall the Senate adopt the conference committee report? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 21, no 17.
Ayes 21, no 17. The Senate adopts the conference committee report.
Senate Bill 5038.
Senator from Roanoke County, Senator Suderline.
Thank you, Mr. President. This is the cognate to the bill that we let go by earlier today. I hope it will be the pleasure of the Senate to allow Senate Bill 5038 to also go by for the day.
Thank the Senator. Without objection, Senate Bill 5038 will go by for the day.
We will not have a conference committee report on Senate Bill 5043, Senate Bill 5081.
Senator from Southern Fairfax, Senator Barker.
Mr. President, I move that we adopt the conference committee report.
Senator, the floor.
This is back to the way we had it when we passed this bill in the Senate originally, and also when we took a House bill and amended it to be identical to Senate Bill 5081. What this does is it requires reporting of outbreaks when there's a public health infectious disease situation such as what we have right now, and it deals with it's a response to what happened earlier this spring and fall and summer when in many instances the governor's office and the Department of Health were not identifying places where there are outbreaks. This would make sure that those places where there are outbreaks are identified. And with that, I renew my motion to adopt the conference committee report.
Thank the Senator. Do any other senators wish to be heard regarding Senate Bill 5081? Seeing none, the question is, shall the Senate adopt the conference committee report? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senator desire to change their vote? The clerk will close the roll.
Ayes 38, no 0.
Ayes 38, no 0. The Senate adopts the conference committee report.
Senate Bill 5088.
Senator from Alexandria, Senator Evan.
Thank you, Mr. President. I move that we adopt the conference report, and speaking to that motion.
Senator has the floor.
This is the mirror image of the House Bill 5064 that we adopted the report earlier. on payment plans, and the language is identical.
Thank the senator. Do any other senators wish to be heard regarding Senate Bill 5088? Seeing none, the question is, shall the Senate adopt the conference committee report? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? Clerk will close the roll.
Ayes 26, noes 12.
Ayes 26, noes 12. The Senate adopts the conference committee report.
Memorial resolutions. Memorial resolutions.
The senior senator from Fairfax, Senator Sasslaw.
Mr. President, I move the memorial resolutions on page 8, that's SR 561 through 565, be considered in a block in the usual manner, waiving the reading of the resolutions thereof with the understanding that any senator desiring to remove a resolution from a block will wait until after the clerk has read the title of the resolution.
Thank the senator. The question is, shall the memorial resolutions on page 8, Senate Resolution 561 through Senate Resolution 565, be considered in the block in the usual manner, waiving the reading of the resolutions thereof, with the understanding that any senator desiring a resolution be removed from the block will do so after the clerk has read the title of the resolution. All in favor of the motion will say aye. Those opposed, no. The ayes have it. The motion is agreed to. The resolutions are before us in the block. The clerk will read the titles of the memorial resolutions.
Senate Resolution 561, celebrating the life of Merrill Lewis Harefield. Senate Resolution 562, celebrating the life of John Manley Garber. Senate Resolution 565, celebrating the life of Lois Sommier Hornsby.
The resolutions will be agreed to in the usual manner. All those in favor of agreeing to the memorial resolutions will please rise. The resolutions are agreed to.
Returning to page 2, House Bill 5049.
Senator from Eastern Fairfax, Senator Servell.
Thank you, Mr. President. I move we adopt the conference report for House Bill 5049. Speaking to that motion.
Senator, has the floor.
Thank you, Mr. President. This bill is identical to provisions in Senate Bill 5030 that we just passed, 21 to something, 18, I think. I would hope we'd pass the bill likewise.
Thank the senator. Do any other senators wish to be heard regarding House Bill 5049? Seeing none, the question is, shall the Senate adopt the conference committee report? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 21, noes 17.
Ayes 21, noes 17. The Senate adopts the conference committee report.
On page 3, House Bill 5099.
Senator from Eastern Fairfax, Senator Servell.
Thank you, Mr. President. I would move we adopt the conference report. Speaking to the motion.
Senator, has the floor.
Thank you, Mr. President. This is the piece that has to do with search warrants and the no-knock warrant situation. I would likewise, we've already passed. I would likewise move we pass this bill.
Thank the senator. Do any other senators wish to be heard regarding House Bill 5099? Seeing none, the question is, shall the Senate adopt the conference committee report? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 22, noes 16.
Ayes 22, noes 16. The Senate adopts the conference committee report.
On page 4, Conference Committee Report on House Bill 5104.
Senator from Eastern Fairfax, Senator Servell.
Thank you, Mr. President. I move we adopt the conference report. Speaking to the motion.
Senator, has the floor.
Thank you, Mr. President. This is the provision relating to the hiring of law enforcement officers and training, and we've already passed this, and likewise, I would hope we would pass this bill.
Thank you. Senator, Senator from Hanover, Senator McDougal.
Would the gentleman yield for a question?
Senator Yield.
I'll yield.
Senator Yield, you have the floor.
Would the gentleman please, and this was one of the provisions that a number of us thought was important to pass, and being in a standalone bill made it possible for us to be able to vote for it. But could the gentleman tell us, because I know he has those red lines of side by side, what the difference between this conference report is and the bill as it left the Senate?
Senator, has the floor.
Mr. President, I have a red line of Senate Bill 5030, but I don't have a red line of this bill pulled out separately. I can tell you that if there was a difference, I've already articulated it. I mean, if you want to take a minute, I can pull it out and we can go by it side by side. But my memory is that this bill had mainly to do with, hold on, let me look at it right here. This has to do with the training that people are required to be given and the training that DCJS has to prepare. And it enhances the training in terms of racism and awareness of dealing with folks that are suffering from mental illness, substance abuse disorder, developmental or cognitive disabilities, and training about racially biased policing. I believe this bill also had the language that I mentioned that when a law enforcement officer changes departments, it broadens the category. It broadens the category.
Sorry, will Senator yield?
Yeah, I'll yield.
Senator Yield. Senator from Hampton, Senator Locke.
Also, one of the changes, Mr. President, originally the House bill mandated that psychological exams be required, and that was one of the things that was taken out, that it is no longer mandated, and that was one of the most significant changes that was made.
Thank the Senator.
Mr.
Senator from Eastern Fairfax, Senator Servell.
Thank you, Mr. President. If you look on lines 3, if you're looking at House Bill 5104, lines 302 through 30, Romanet number 4 on line 302, that's new. That was something that the House added, and then I believe the senator from Hampton got the other change.
Further question?
Mr. President, gentleman would yield for further question. I don't want to belabor the point. Again, this was a bill that I think originally as it passed the Senate, some of us voted for, but in my version of those lines around 300 to 307, there's no changes. So I would ask the gentleman again, if maybe if we couldn't figure out what the difference is between the one that passed, could we take this by for the day and take it up when we come back? Because I'd like to be able to vote for it if the changes are not substantive from what we passed the Senate originally.
Okay. Senator Yield, you have the floor.
Mr. President, what I would say to the senator is I suspect that was not a change from the prior version of 5104 to this version of 5104, but this version of 5104 was inconsistent with Senate Bill 5030. And so I was talking about the changes we made to 5030, which is why I call those things changes, but they may have been in 5104 when it went through already and we didn't have a problem with it, so we sent it through when you voted for it. That's my guess is why I'm calling it a change and you're seeing it as not changed. I don't know if that helps make you feel more comfortable about it, but I think that's why we're seeing it a little bit differently.
Further question?
Mr. President, no, that did not make me more comfortable, but I understand. I guess when I'm looking at it, if it's not underlined, then that's either current law that's not being changed in this version. If that's not how this is, I guess I have even more of a request that it go by for the day.
Mr. President, can you go by temporarily so we can talk about it a little bit? No. Temporarily. Do we have any others? We have a couple more.
Substitute motion to go by temporarily. Is there any objection? Without objection, House Bill 5104 will go by temporarily.
House Bill 5106.
Senator from Southern Fairfax, Senator Barker.
Madam Clerk, a little advice here for this situation. I've communicated with the patron of the bill. The patron of the bill is looking to have create a second committee of conference to deal with the issues raised by 3 senators in the discussion earlier. And I just need to know what types of motions I need to make to get to that point.
For what purpose, Senator from Fairfax City, Senator Peterson rise?
To provide assistance.
Senator has the floor.
Mr. President, with a recommendation that we reject, I move that we adopt the conference report.
Thank the Senator. With the recommendation that it be rejected, the question is, shall the Senate adopt the conference committee report? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Yeah, maybe.
Ayes 1, noes 37.
Ayes 1, noes 37. The Senate does not adopt the conference committee report. Senator from Fairfax City, Senator Peterson.
Mr. President, I would move that we create a second conference committee. Is that the proper motion?
Committee of conference, yes.
Appoint a second committee of conference.
Question is, shall the Senate request a second committee of conference? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 28, noes 9.
Ayes 28, noes 9. The Senate requests a second committee of conference. Without objection, the Senate will be at ease.
We have to wait. Yes, Tara says we have to wait. Okay. Don't we have to wait?
Okay, so you're sending the insistent request on second?
Well,
Of course, of course. Senate will come to order. The senators will please take their seats.
You know, when I do my reality TV show, you can't make this stuff up. Okay. You don't have to.
You okay?
On page 45104.
Senator from Eastern Fairfax, Senator Somerville.
Thank you, Mr. President. I'd move the bill pass. And speaking of that motion.
Senator has the floor.
Thank you, Mr. President. I think this is our last bill and the last part of the police reform bill. I've spoken with the senator from Hanover. I believe he's now satisfied, or he can speak now or forever hold his peace, but I would hope we would now pass the bill.
Thank the senator. Do any other senators wish to be heard regarding House Bill 5104? Seeing none, the question is, shall the Senate adopt the conference committee report? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? Clerk will close the roll.
Ayes 31, noes 5.
Ayes 31, noes 5. The Senate adopts the conference committee report.
Mr. President,
Senator from Roanoke County, Senator Suderline.
having voted on the prevailing side, Mr. President, having voted on the prevailing side in which we just adopted the conference report for House Bill 5104, can we please reconsider that vote so that every member may be properly recorded?
Thank the senator. The question is, shall the vote by which the Senate adopted the conference committee report for House Bill 5104 be reconsidered? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? The clerk will close the roll.
Ayes 36, noes 0.
Ayes 36, noes 0. The motion is agreed to. Senator from Eastern Fairfax, Senator Somerville.
Thank you, Mr. President. I move we adopt the conference committee report and speak to the motion.
Senator has the floor.
Thank you, Mr. President. This is the bill we just voted on. I hope this is our last bill.
Thank the senator. Question is, shall the Senate adopt the conference committee report? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senator desire to change their vote? The clerk will close the roll.
Ayes 31, noes 5.
Ayes 31, noes 5. The Senate adopts the conference committee report. Senior Senator from Fairfax, Senator Saslaw.
Mr. President, I require the clerk, does that complete the calendar for today?
Yes, sir.
Thank you, Madam Clerk. Is there any other business to come before the Senate? Senator from Northern Fairfax, Senator Howe.
Thank you, Mr. President. I just want to make a brief announcement.
Senator has the floor.
1 hour before we come back in session on Friday, which I think will be 3 o'clock, is 1 hour before when we come back. But in any event, 1 hour before we come back, the Senate Finance and Appropriations staff is going to be here to brief any members on the conference report. And if anybody is not going to be here but would like to participate remotely, please let them know that. Thank you.
Thank the senator. For what purpose is Senator from Bath, Senator Deeds rise?
Mr. President, I apologize in advance. I've got a brief point of personal privilege.
Senator has the floor.
2020 has been a heck of a year. Bob Gibson, Joe Morgan, Al Kaline, Lou Brock, Tom Seaver. But this morning I looked at the clips and I saw that our friend and colleague Bernie Cohen passed away.
I was going to bring that up.
You know, I served in the House of Delegates for 10 years. I came here at the same time as a senator from Bedford. We were both in the House of Delegates, and the senators from James City County and Portsmouth and Northern Fairfax County were also, they came to the House at that time. For those who, Bernie was the first guy in the House. Back in those days, we had bill books. You know, Bernie had, he was the first guy in the House to have a computer. He told me one time, you know, during this session, I don't read an email from a constituent. I don't read a letter from a constituent. I don't return a phone call from a constituent. because I'm afraid it might influence me. For those who are students of Plato's Republic, you will understand what that's all about. Bernie truly came out of the cave, saw the light, and his job was to bring it back. He told me that if his constituents disagreed with him, it was his job to go back and educate his constituents. Now, there are three ways to leave this place. You can die, and we're all going to die. You can be defeated, and a whole lot of good people we know have been defeated. Or you can leave on your own terms. Bernie Cohen left on his own terms. You know, Townes Van Sant wrote a song one time, and he said, life is mostly wasting time, and I've wasted my share of mine. And I guess we can all say that. You know, those of us who are blessed to get elected to these sorts of offices, we have high opinions of ourselves, but the reality is, except for a very few of us, within a few years after we're gone, nobody will remember us. Nobody will remember us. We might just be a name in a book. But Bernie Cohen mattered. He mattered before he came to the General Assembly. He stood on principle the whole time he was here. He was an unbelievable Virginian. And I would ask that when we adjourn today, we adjourn in honor and memory of our friend and colleague, Bernie Cohen.
Thank the senator. For what purpose is the senior senator from Fairfax, Senator Saslaw, rise?
First, with a brief announcement that any memorial and commending resolutions after today will be for the 2021 session. The other point of personal privilege was about former Delegate Bernard Cohen. Bernie died 2 days ago at age 86. I first met Bernie back in 1979. He was running for the House of Delegates, and I was running for the state Senate. And he was one of the brightest guys that I've ever met in my life. I was just a super intelligent fellow. 7 years out of law school, he and Philip Hirschkopf took on a case that became one of the landmark cases before the U.S. Supreme Court in the history of this country. Back in 1924, which was one of our worst moments, the General Assembly passed, if you can believe this, called a Racial Integrity Act. That's what Richard and Mildred Loving were accused of violating when they got married in the district, and they were asleep at their home. They then came out to, I think it was Hanover County, but I'm not sure. Caroline. And at 2:30 in the morning, the sheriff breaks into their house and arrests them for violating that act. That was in the mid-'60s. Bernie Cohen and Phil Hirschkopf took up that case a couple of years later and took it all the way to the U.S. Supreme Court. And in a landmark ruling, they struck down Virginia's ban, as well as 15 other states, on interracial marriages. And I didn't read the decision. It was a 9-0 decision by the Supreme Court, but it was pretty harshly written and directed at Virginia, and should have been. That was definitely not one of our better moments. And it took Bernie Cohen and Phil Hirschkopf to put an end to that. That act came out of one of our most disgraceful periods. And thank God that's all over with. Bernie was well-liked by almost everyone that met him. And like I said, just a super brilliant legal mind. And when he retired, he didn't run for re-election in '95. And General Assembly, let me tell you, the average IQ level dropped as a result of Bernie leaving. He was just that bright. And so, it's already been requested by Senator Deeds that when we adjourn today, we do it in Bernie Cohen's memory, Mr. President.
Thank the senator. For what purpose does the senator from Prince William County, Senator McPike, rise?
Thank you, Mr. President. Just a brief moment of personal privilege.
Senator has the floor.
Thank you, Mr. President. Today we passed a memorial resolution to Manley Garber, and I just wanted to speak to that for a brief moment. Manley Garber, I think many of you met actually at the agribusiness dinner and other things over the years. He was a fantastic gentleman and great spirit for Prince William County. He grew up initially in Augusta County and moved to Prince William County, where he worked on the family farm. He was an entrepreneur, owned several small businesses, including a hog farm, and he was an early advocate actually for something called electricity in Prince William County, if you can believe that, and was elected to the Prince William Electric Cooperative at age 25. He served an amazing 68 years on Prince William and future Novak Electric Board, serving also as its chairman from 1983 to 2008. Just a tremendous amount of service, also serving to the communities, hospitals, other nonprofits, to ensure the community grew together. And it was individuals like that as a civic activist that really made things possible. And if you can think about it, from when he moved to Prince William County, it was still farming. And he had the foresight to really ensure that all folks had access to some of the basics like electricity, and did so and committed his life to improving the community. And I just want to thank the body for adopting that memorial resolution, and also ask when we adjourn we do so in memory of Manley Garber. Thank you, Mr. President.
Thank the senator. For what purpose does the senior senator from Virginia Beach, Senator D. Steph, rise?
Mr. President, I rise for a point of personal privilege, a brief one.
Senator has the floor.
Mr. President, in August 2019, Harry J. Williams was denied parole. Why, you ask? Well, there are 3 reasons that the parole board gave him, and then just 10 months later, before they decided to let him go this past June 22nd. The first, his history of substance abuse. The second, the serious nature and circumstances of his offenses. And third, his prior failures and convictions while under community supervision indicated that he's very unlikely to comply with conditions of his release. But as you all know by now, never before has there been a single-year period of such apparent incredible rehabilitation of the Commonwealth's prisoners. In 2020, a record number of convicts are now miraculously no longer a threat to the citizens of the Commonwealth, or so the parole board would like, and their actions would seem to suggest. But let me tell you about why Harry Williams was in jail. Mr. Williams was convicted of first-degree murder for shooting and killing Mr. James W. Sarver in his home just northeast of Danville in Pittsylvania County. Williams went into Sarver's home. When Williams got there, Mr. and Mrs. Sarver, their 14-year-old son James, their 13-year-old daughter Linda, and their 2 younger daughters Diane and Nancy Marie had gone to bed. Hearing a noise, Mr. Sarver went to the front door. When he opened it, Sarver briefly talked with Mr. Williams, which after Williams shot James in the head, killing him dead. As Mr. Sarver fell to his floor at the front door dead, Williams entered the house, went into 2 of the bedrooms, shot and wounded his wife, shot his 14-year-old, little Jim, in the stomach, and then shot 9-year-old Nancy Marie in the chest. Williams then shot again, but missed Mrs. Sarver. His gun now empty, he tossed it and grabbed little Diane around the neck and shook her like a chicken, trying to break her neck and choke her to death. Linda, who is now 13, followed Williams when he was carrying the younger Diane out of their bedroom, saw her mother in the hall. It looked like Williams had brutally beat her mother. To protect her mother, Linda, who was 13, struck Williams with a mop or broom handle, whereupon he grabbed Linda by the hand, dragged her out the front door of the house. While he was dragging Linda across the front yard, the lights from a passing automobile lit up the front yard. Mrs. Sarver, who was following Williams and Linda, shouted that the police were coming, and like a coward, Williams ran.
Mr. President, do we really believe this man has been reformed in 10 months? I ask the members of this body, I ask the governor, the administration, and the parole board, do you really think in 10 months this horrible, cold-blooded killer is reformed? I hope you do, because as of July 22nd, he's walking our streets, he's walking our neighborhoods, he's walking outside of our houses. What's it going to take to keep these cold-blooded killers in jail? Mr. President, the first 8 months of 2015, the parole board released 62 prisoners. Just 5 short years later, over the exact same period of 8 months, the parole board has opened the gates, releasing hundreds more prisoners, cold-blooded killers, rapists, child sexual predators, and child rapists. I ask you, Mr. President, what's it going to do, what's it going to take to keep these people in jail? We keep passing bills that exclude murderers, rapists, child sexual predators, child rapists, but it doesn't matter. Because when the governor, the administration, the parole board get involved, they ignore, I say again, ignore our laws and let these horrible criminals out of jail, back on our streets, back in our neighborhoods, back in our houses. Mr. President, what's it going to take to make a difference and keep these cold-blooded killers, rapists, child sexual predators, and child rapists in jail? For what purpose does the junior senator from Richmond City, Senator Morrissey, rise?
Thank you, Mr. President. Mr. President, I rise for the point of personal privilege.
Senator, the floor.
Mr. President, I want to follow the eloquent words of the senators from Bath County and Fairfax. I too knew Bernie Cohen. I knew him for almost half a century. I knew him in a different perspective than what has been shared with you. Bernie, my father practiced medicine in Northern Virginia, cardiology and internal medicine, for about 40 years, and his partner was Ron Apter, who I always reverently referred to as Dr. Apter. Dr. Apter's brother-in-law was Bernie Cohen, and Bernie was over at our house for many, many years. And I remember the first time he came over. I was 10.